All right, we're back on the record? Or, okay, we're back on the record at 10:14 a.m. We're gonna wait for Ms. Verdugo Peralta. So we're down to an item number one, amendment to rules and procedures of the South Coast AQMD Hearing Board. And so I'll go ahead and turn the floor over to the hearing board's attorney so that he can provide some context as well as content.
Thank you, Mr. Chair. Good morning, members of the hearing board. So there's been a lot of ongoing conversation, as you all know, over the years of the best way to handle items that are potentially on the consent calendar and ways for the hearing board members to obtain the information they need in order to make a ruling on items that are in the consent calendar. We did present an option last year that had a lot of sort of back and forth between members of the board going to posing questions through the clerk that would then be rerouted to the petitioners and then back through. And there are concerns that while it may be technically compliant with the Brown Act, it presented opportunities for errors to be made that would result in Brown Act violations. And there was a request to sort of simplify that process. So what we're presenting this morning is an attempt to balance several concerns. One is to allow the Brown Act members to feel comfortable that they've obtained all the information they need before ruling on something that is potentially on the consent calendar. The other is to maintain the ability to utilize the consent calendar for the efficiency it brings and for the cost savings that it brings. And so what also obviously to remain Brown Act compliant. And so you've seen this was one of the agenda items attached to today's meeting is a proposed new Rule 4C. There is no C right now. This would be a new section to Rule 4. And the way the process essentially works is when an item is listed as potentially being on consent calendar, the clerk would provide the information for that matter to the board members, along with a couple deadlines. One would be a deadline by which the board members would request to the chair or the chair's designee that a matter not be held on consent, and to state the reasons why that's the case, maybe some current concerns, maybe you have questions you'd like to ask the parties to bring them in person. And the clerk would set a second deadline by which the chair would make a determination as to whether that item will be on consent or will be instead in a full hearing. At that point, the clerk would obviously take the steps necessary to either keep it on consent or to move it to a full hearing. And that's essentially the short of it. And so Part 4 says that when a matter is on consent and we're the day of and a member has substantive questions, they can make a request to the chair at that point that the item be moved off of consent so that the parties can be brought at a future date, noticed date for asking those questions. I will note too, in reviewing the rest of Rule 4, in order to implement this new Rule C, there is a minor, what I would consider a ministerial change for continuity that I'd be happy to, it's just a striking through of a couple of words here. So with the chair's permission, can I pass these out here?
Absolutely.
This is existing Rule 4. I'll wait till I get from my.
Yes, sir.
I've got some copies for the public here.
Will that be emailed to me?
Yes, Ms. Verdugo Peralta. So what I've handed out is the full text of Rule 4B4 as existing in the current procedures. And I'll read you the first full sentence first. The rule states, at any time prior to the submission of the case, the hearing board shall immediately remove a matter from the consent calendar upon the written or oral request of the respondent or the petitioner or any hearing board member, and shall hear the matter on the scheduled hearing date or shall assign the matter to the next available hearing date while fully complying with notice requirements for the type of the matter at issue. And the suggested alteration is to strike the words "or any hearing board member" because that is inconsistent with the proposed new rule 4C. So with that, that's the end of my presentation. I'd be happy
Thank you.
to answer any questions.
Thank you, Mr. Attorney. Members of the hearing board, any questions, comments associated with this matter?
Yeah, I do have several concerns regarding this, so now you're adding another layer, of going to the chair and getting the chair's permission. Is that or the designee, let's say there's just a chair,
Yeah, this does give some discretion to the chair or the chair's designee as to whether to move it off of consent to a full hearing. Correct.
And does the chair then have to justify why he's doing that?
Well, I mean, there's no requirement here for any particular findings. We could put a, clause for a good cause or something like that.
Okay, now, I'm trying to understand what's the genesis for why this is, occurring, I know the chair has been upset sometime when, a matter, I pulled it out, consent, and I compiled some data, in 2025, out of 14, one was pulled out of consent. In 2024, 3 out of 50 that came for consent, and one of them I point out was clear violation of the health and safety code, and as were some of the others administrative, requirements in the health and safety code were not complied with. But one, which is in the existing rule, just say if it's going to be a nuisance issue, it shouldn't be, it shouldn't even have come to us for consent, but it did. And I pulled it. None of the other board members said anything about it, which was in violation of the current health and the rule. It says if you got a nuisance potential, there was a landfill and so forth. So a member who then sees, so let's say in that that it was a real case, the chair didn't see fit to pull it. I did. So let's say we went to the chair and the chair said, no, I'm going to override it. And in clear violation of the health and safety code also, what's the remedy for that?
So the remedy would then be, at the time the consent matter is considered, you would raise it again on the record, state your reason, and there would be a deliberation about that.
But you lost the opportunity here for having them here to explain to the public the issues, because it's, in that case, it was a health and safety issue in complaints and so forth. And it has a value in getting those parties in here testifying under oath and, asking them questions. It was not a matter that should be considered under a consent hearing.
Mm-hmm. Well, the request from the member at that point would be to reschedule it to allow them to come in. So you would be losing the opportunity for that morning, but not.
Yeah, but then can it be overridden? Is it just because a member, does the full board then have to vote for it? Or what's
Dr. Abraham.
I would like to add some comments here and kind of address some of the concerns that Mohan's raising. I really appreciate the fact that, let's say this hypothetical scenario plays out.
No, it was a real scenario.
Okay, let's say a real scenario, but in this case, you came back here in this real scenario. Then let's talk about the real scenario. Did you come back here and make the appeal as to why it should not have been seen on consent?
No, I said no, it should not, because I put in the email.
I see what you're saying.
I put actually in the email, the first thing is the violation of the health and safety code. So I did put that in the correspondence, which everybody got.
Yes.
So yes, you all got.
Okay, now let's move to the hypothetical. So now let's say we implement this rule change. Now it's at the discretion of the chair. You're still dissatisfied. What Dale just mentioned, I really appreciate on the record at the next meeting why, maybe however you want to frame it, a failure of both parties, respondent and the petitioner and the hearing board did not catch this error and they want to do this anyway. Air your grievance there. And if we still vote in the majority to pass the order as written, that is the reality, and the liability of us passing something that is in conflict with our rules is a consequence we will have to live with. And we're balancing all of this against the efficiency and the trust that we have in the public that we're moving through the business so that we actually make sure for the greatest good, we're accomplishing the work with the greatest impact. If we go down editorial or administrative, it'll edit changes every time, which is not the point here, but I'm just saying there can be instances where are we pulling everything off of consent? And I saw and I hear the data that you presented, but I think this is an important safeguard, a guardrail that protects us in being able to actually also conduct the business we need to efficiently. It puts more onus on our petitioners and our respondents. And please don't bring stipulated orders that have not been well thought through. But that's the fear too, is that by you having those exchanges and then the clerk and this chain, and then all of us were in the dark, we end up with hourly in the order, right? When it should have possibly had we had a chance to actually discuss it. I'm not saying what the answer in that case is, because clearly we can't discuss it because of the Brown Act. But should hourly stop the whole process and require two parties to come in when something can be resolved about that?
To your point, you're not in the dark because you are getting the communication. It becomes a hearing board exhibit. It's part of the record, what was communicated. And so most cases it's sent to you before the hearing. In some cases it's given on the day out because of the last minute filing and responses. So you're not in the dark. However, the several members and I have not provided a single comment on all this, hearing board requests for on consent, when they were clearly have been procedural administrative violation. And I'm just amazed that a board member is not picking up or commenting on some of these errors. Mr. Pearman has, I have. But there hasn't been a single hearing board exhibit from 3 of the members, all, the last 3 years, I can say. Why is that? Is my one question. So, so I feel it's my responsibility when they submit for consent to provide comments, but if I have to go through the chair and the chair gets to approve it, it just, then does that go to the parties so they know what the errors are and they can correct it? Or, I just fail to see the procedure, and some of this, when I do the correction, and you see it's the format, or you've got the wrong template, or they've got the wrong rule reference, it gives an opportunity for them to correct it and submit corrected documents for the hearing. Because, the consent hearing, while the regular variance is open to the public, we are seeing more and more coming for interim and emergency, like in the case today, where the public is not informed on it. Okay. So there's no correction to the, so if you talk about efficiency, then now we have to then reschedule another date to get this hearing, to redo the, while that's already been scheduled. Let's say the public knows today is the hearing date, and then I come and say, you know what, this is an issue with a violation of the health and safety code. We cannot proceed. We have to redo it and go forward.
Yeah, go right ahead, and then we're going to go to Ms. Verdugo Peralta.
I just have some of those comments, sir, because they're very important. And yes, I do feel that we are ensuring that both parties are heard, including the minority position perhaps, and that happens here live. And even if we still move forward, I think it really speaks to more systemic issues. But I will say, to some of the points you're raising, there's a reason why you are the engineering member of this board, and you have a knowledge and a skill set that we do not have, especially as the public members or the medical member. You understand the rules also very differently as the engineering member. So I'm not saying that I'm defending why you don't hear from other members, but you are clearly here in a very specific technical capacity. We're not surprised, therefore, that the engineering member in many ways is catching the nuances of some of the technical repercussions of what's written in the proposed findings and decision and ultimately the order, right? And I'm just saying that because I can read the exact same document you, I just will never have that engineering lens, the air quality, science, understanding, and then how that interfaces exactly with the rule. The reason why I'm not, calling on Mr. Pearman here, but the attorney member, there is a reason why we have an attorney member up here. So we do get it right, so that we're not violating the law or our rules. And so again, we wouldn't be surprised when we see from that legal lens why an issue needs to be raised or pulled off of consent or this, that. I'm not saying that the public members and the medical member have a disadvantage in that regard, but it definitely speaks to why you may not see us speak up on some of these nuances in a way, but you will see us speak up when we need to speak to remind us why we're here, representing the health of the public or understanding the health harms of the policy or the rules change that we're going to make. So I just want to put that out there, and it's not as if I just want to ultimately say, I do not personally as a person feel that all the burden is placed on you to catch everything. And it is your sole job to kind of figure it out, and that everybody else is just sitting here and watching and then come here and vote.
Thank you, Dr. Abraham. Very magnanimous comments with respect to the concerns as levied by Mr. Balakapalan. Ms. Verdugo-Peralta.
Thank you, Mr. Chair, and thank you, Dr. Abraham, for stating that, because that's basically what I was going to comment on. Just because we do not write a comment to whatever the emails that go back and forth, or whether, it's going to be on consent, if something has already been stated, there's not necessarily a need to state it again. And there are 5 of us. My other concern is this. There are 5 of us. We all come from different backgrounds. We all have different specialties. And for that reason, in particular, feel that it is equal. It's more equal if there is one person, one board member who has a concern and wants to pull it, that they have that right to pull it. I'm not necessarily, and having been the chair in the past, I am not necessarily in agreement that it only should be the chair that ends up deciding whether it is going to be on consent or not, because of the fact that we all have different backgrounds. The only thing I could possibly add to that would be the person who wants to pull it should then therefore write a reason, document a reason why they want to pull it and justify it in that way. But it concerns me that a chair would be able to say, no, I don't think we should have a full hearing on this, and we should leave it on consent. That's my concern. And it's because I respect the fact that each of us does have a different level of knowledge of AQMD rules and regs, and has a different perspective, whether that be from the medical side, the attorney side, the engineer side, or us members of the public, Mr. Chair. So in particular, having witnessed this hearing board for many years now, appreciate the fact that if one member wants to pull it, that they have the right to pull it.
Thank you, Ms. Roberts. I'm sorry, Mr. Pearman.
So the way I looked at this is currently one member can pull from consent. And so I look at this, if it's only going to be in the hands of one member, shouldn't that member be the chair? I mean, that's why we elected he or she the chair, that we respect their judgment. Otherwise, we wouldn't have voted for them. So when I look at it from that standpoint, it kind of makes sense. The way the proposed rule is written with the addition, the objecting member still communicates their concerns. They can still be communicated through the clerk to the parties, and the editing feature that happens now may still occur. And then the chair is in a unique position because, again, within the confines of the Brown Act, could be made aware of, say, that one member's concerns. He or she, as the chair, would also know about scheduling issues and the like that might have affected how the parties brought this before us in the first place. And all those things are relevant factors to whether you decide to pull something or not. And so I think he or she's in a better position to make that judgment. And, again, if the chair makes bad judgments in terms of not pulling things when there's been sound reasons by a member. We can always impeach the chair at some point. So I see this as not really that much of a change. It just makes sense that if there's going to be one person with that kind of veto, it should be the chair. And let's try it. If it doesn't work after a year, we can go back to a different formula. So I'm willing to support it.
Thank you. Ms. Roberts.
Thank you, Mr. Chair. I'm Catherine Roberts, Principal Deputy District Counsel with the Office of General Counsel here at South Coast AQMD. The General Counsel's Office sincerely appreciates the board holding this meeting, and we thank the board members for reviewing the hearing board rules and opening a dialogue on how best to optimize the hearing process. As proposed, the General Counsel's Office does have some significant concerns with the proposed 4C and ultimately does oppose the adoption of the amendment. The General Counsel's Office concerns fall into two primary categories that I'd like to raise. First, we believe the proposal allows discussion of an item on the agenda amongst board members outside of a public meeting, and that runs afoul of the Brown Act. Notably, the Brown Act prohibits not only the board from deciding a matter outside of a meeting, but also prohibits even discussion amongst the board members themselves of any item of business within the board's jurisdiction outside a public meeting. The Brown Act also expressly prohibits these types of discussions, even when it is done in a serial format, where only one board member at a time is communicating with the chair. This is what item 4C, item number 2, is proposing, and so we believe it would create a violation. Second, and separate from the Brown Act issue, the General Counsel's Office believes that the proposal would introduce significant uncertainty into the consent process and is ultimately likely to disincentivize use of the consent calendar. Specifically, item number 4 of 4C creates the potential where a matter has already been approved for the consent calendar, but is taken off consent and rescheduled to a later date without prior notice to the parties. For facilities that are needing timely relief through the variance process, this creates a significant risk for the facility that if it considers consent, their ultimate relief might be delayed. For facilities that needing a variance, usually it is because they either cannot operate in compliance, which would expose them to significant civil penalty liability until relief is granted, or because they need to do repair and maintenance, which might take significant scheduling in advance, and they need to be able to rely on when the hearing is set. Because of these are likely to create significant risks to the facility, we believe there is a high likelihood that parties might opt to not use the consent, even though the matter might otherwise be appropriate for the consent calendar. The General Counsel's Office considers the consent calendar such an important tool because it increases this board's efficiency and reduces burdens and costs to the parties. The General Counsel's Office thus is forced to oppose the proposal on these grounds as well. We greatly respectfully recommend that the board retain the existing Rule 4 as it is written today without adopting the proposed language. We greatly appreciate the board's efforts to enhance the hearing board's operation, and we stand ready to continue this dialogue and work with the board through these general meetings to find additional efficiencies and optimizations to the hearing board process. I'm happy to answer any questions you have regarding the General Counsel's position on this, and I thank the board for their consideration.
Thank you. So the motion that we'll lay up on the floor, the motion would be the recommendation to approve the amendments to the rules as proffered. You could speak on the motion. The motion would be, Mr. Counselor?
The motion would be to adopt the proposed new Rule 4C with the minor amendment to existing Rule 4B4.
I'd like to move that motion.
I'll second.
All right, it's been moved by Ali, second by Mr. Perriman, Madam Clerk.
Yes, I'd just like clarification for the clerk's office, how this process will play out.
Okay, all right, so and once it's approved, then we'll get you an administrative rule. All right, on discussion.
The discussion, okay. Let me take a different approach. I think the more appropriate approach is to indicate what shouldn't come on consent calendar so that, everybody knows, like it's a violation of the health. The Bay Area actually has the rule also very similar to this, and I looked at that.
Yeah, I know.
And they said, okay, anything that, which will violate the nuisance should not come to the consent. So it's very clear that it shouldn't even come to us, that, the party should know we shouldn't file a consent. Or if they went even further, they said that, any matter of concern that involves emission of toxics, undue harm to public, other potential nuisance. So it's very clear that, sets the guidelines saying, don't send this for consent because these are public issues, public concerns and so forth. So those, and then my frustration is, sometimes I feel like I'm a school teacher. I get this. Oh, well, let me back up a little bit. I think that there's an impression in some board members' mind that because it's stipulated and both sides have agreed to it, we should just be agreeing to it and just essentially rubber stamping it. Hey, I heard I'll put you on the spot here, Mr. Abraham, saying, the attorney for the district who represents the EO said this, how can you oppose that? Kind of situation. I'll just like to remind board members, in 2022, we had a case that came before us. It took months. The district worked very hard on that case with the party, and they came to a stipulated order of abatement. You were not here at that time. It was a health impact issue, ethylene oxide. And the board, to my was very concerned and voted unanimously to reject the stipulated order of abatement. And then the district subsequently said, came up with a new proposal, and they said, oh yes, they came up with the numbers which are even lower than any that the board member had proposed. So that was a case where a stipulated order of abatement came before us, and we had the right to listen to it and to make changes. So just because it comes stipulated and both sides, and there's so many errors in some of these documents, and every time I send these corrections and they correct it, and then it's a different lawyer, attorney, the same errors comes up. Come up, and I don't mind because it's, send that it's a minor thing. It's not a big deal, except when I see it's or there's a red flag, warning to something tells me that something is amiss here, and I oppose it. But I always give a reason why. I think, except that one case, the last one a few months ago, I was ready to send out. I had all my questions. Auto send on Tuesday morning. I woke up Tuesday morning to do an edit, and I said, no, I'm going to oppose it. And what happened? The day after, they came into compliance. Now, I don't know what happened, but anyway, there was a gut feeling that something is amiss with this request, But gut feeling is aside, I think we should put down, I agree, what's the reason why you're opposing the request. So if you want to change it, be upfront what shouldn't come before us. If it's a violation of health and safety code. And here's another violation of safety code. I can give you several examples that I went through. I went through all last 3 years of all the comments I sent, and I didn't get Mr. Pearman's because I don't have the email. I know Mr. Pearman has done some. And there were numerous where is a regular variance more than a year. The parties have not put in the increment of progress, which is a violation of the health and safety code. So I have to send the thing saying, no, you need to change it. You need to have increment of progress because the health and safety code section 42358 requires that. That is clearly an administrative error, which could be an issue. It's challenged in court because there's a violation of the health and safety code. The same thing if it's going to have a health impact. So if you have a case where there's hexavalent chromium, and it coming for an interim or an emergency where there's no public notice on that, that is an issue, so a board member should be able to, and it doesn't have, you saying the engineering member has the knowledge. No, I can remember in the past when we had hearing board members who were public members who actually knew better the rules than I did and were asking very good questions. And you have an open dialogue when they're here and they ask questions, then you feed off on each other, sometimes on this. So it's not necessarily the engineering member or the attorney member should be doing. All members equally should be participating. It shouldn't be up to 1 or 2 members to catch some of the, we've gone through this process of some training, some of these administrative errors. A board member may miss it, like I did the hourly and the GPM, but somebody else, if they looked at it, may see it. The fact that 3 people have not submitted any single comment, for me, it's worrisome. And then to say, we'll let the chair decide because the chair who has not provided a single comment, for me, that is somewhat worrisome, and I.
So you want to know why I've never provided a comment in email?
Yeah.
Because I have a concern with the process. I have a grave concern. I've been elected for nearly 20 years. I've never had a Brown Act issue. I'm very concerned by the process. So I do not communicate my concerns. If there are concerns, the concerns ought to be brought to the dais. This, what the attorney has proffered, is a measure of transparency, making certain that objections ought to be raised on the floor, not an email back and forth, because now you get off into an ex parte issue. Now you get off into one board member being the representative of the whole. Now you get off into a petitioner or respondent believing that one hearing board member has made modifications, their own modifications predicated upon their own research done outside of the hearing board meeting. So there's a tremendous amount of concerns with the process, which is why, so I don't want us to levy concerns or bring up grievances with respect to why other individuals may not reply. I believe the question ought to be why. The question ought to be why. And in many governmental entities, this is a very unique body. There's no governmental entity, city, county, special district, or school district, where there is email traffic between staff prior to an agenda item. It just does not happen. In this particular instance, it's slightly different. But all concerns ought to be vetted and aired in the light of day, which is why the Brown Act exists. To that end, we're calling for the vote. Dr. Abraham, your vote?
I did want to make a comment.
Oh, go right ahead, Verdugo Peralta. You be the last comment.
Okay. I'm just concerned that we're going down a slippery slope. It's in addition to what Catherine did say, but it also, again, to me, dilutes each of the specialties that each of us have. And I appreciate all of those specialties and welcome all of those specialties and want to hear all of those comments from those people. So those are the reasons that I don't think that it's a good idea. Thank you.
All right, Dr. Abraham.
Oh,
You voted? Oh,
I'm just thinking, sorry
okay.
about that. There was one thing that I felt like I was still, after hearing from the AQMD attorney, I did want to hear Dale's perspective on some of the comments that were raised so that we're not passing something that's obviously in violation of the Hearing Brown Act.
Sure. The way this is designed is that there would be an email between one board member and the chair, and there would not be a quorum, there would not be a meeting. And so we do not view it as a Brown Act violation. The other point that I believe Ms. Roberts raised on sort of the efficiency, taking away the efficiency of the consent calendar, I disagree. I think this actually makes things more efficient. The deadlines that the clerk imposed, and we can talk about this more, are designed to make a determination by the chair whether this is on consent or a full hearing in advance of when the item would be posted on an agenda for that item. So the item would take place on the same scheduled date as was known before this. The issue would just be whether or not it's on consent or a full hearing. So it wouldn't cause things to slow down or to have to reschedule if this is followed as written.
Thank you.
No. We're voting. Dr. Abraham,
I vote aye.
Ms. Verdugo Peralta,
No.
Palaka Palan.
No.
Pearman?
Aye.
Ali votes in the affirmative. The matter is passed 3-2. Thank you very kindly. Mr. Attorney, I would presume you would work very closely with the clerk's office with respect to an administrative regulation of some sort as to how this will be implemented.
Yes, I'd be happy to work with the clerk on
And then
that.
we can bring back well, I guess you work on the admin rules, and so you guys they don't come to the board for approval, right? Madam Clerk, whatever the administrative regulations that would exist as far as how to implement something would be done ministerially. All right, we're going to
Before
move into. Ma'am?
I'm sorry to interrupt you. I wanted to ask Mr. Larson a question before we lose him because we don't get him that often. And if I may, before you adjourn, ask a question
here
of
for the-
Mr. Larson.
He's here for the training, so we're getting ready to roll into the Brown Act training now. But you can go right ahead with the question.
Okay. Based on the fact that I in particular have utilized 3 of the 7 medical excuses that we get, I want to know, is it based on a fiscal year or is it based on a calendar year?
So the law itself does not state explicitly. In that case, I interpret it as the calendar year would be the typical interpretation for a statute that doesn't state.
Even though the agency is on a fiscal year.
Well, so I mean, it does say, let's see here. Yeah, I mean, it just says 7 minutes per, or 7 meetings per year. I mean, I think you would have a defense that if you look at any 1 year period, you've not missed more than 7. That would be one interpretation I think would be defensible. The other would be to look at a calendar year.
I was going to say our term is on a fiscal year. You know, we start July in the new term. Yeah. So if you do, you know, technically you could game in and say end of the year and then I got another year, you know.
It's interesting that and we'll talk about this during one of the slides, that when it was 20% of the meetings, it did say within a calendar year. You know, that could lend to different interpretations of the fact that it no longer says calendar year, but you know, I think the fact that they said calendar year before provides some weight that that's the intent of this as well.
But then my question becomes, why did they take it out? Because
That's
there
the
are
other,
some-
like I said, there's different ways you can read into that.
Exactly, and this agency has run on a fiscal year, and not just our terms, but also the entire agency is on a fiscal year.
Yeah, I mean, the other factor in this is that the new provisions for remote participation are set to sunset as of December 31st of this year. So that may change whether it's relevant. Essentially, that will be the end of the counting period.
All right, so I want to introduce our two alternates. Why don't you just introduce yourself, please?
Maria Williams Slaughter, alternate for engineer member.
Steve Semeniego, alternate for the public.
All right. Mr. Attorney, you have until 11:30 to do your Brown Act presentation.
I don't think I'll need that long.
Very well. Now, just so we're clear, folks, he's really doing the amendments, and there's been several this year, so he can walk through that as he can provide his own
Yeah,
preface.
this is not a full Brown Act training. I am not going through all of the Brown Act requirements. It's merely what has changed in the law since the last time we did do a full Brown Act training. And essentially the last time we did this was, I believe, July 2023. So if I go to that next slide, please. The first change is the one we were just talking about with Ms. Verdugo Peralta, which is calculating how many times a board member can use alternative teleconferencing. And these are two provisions for remote appearances that were added to the Brown Act as a result of COVID. And the two provisions are the just cause provision and the emergency circumstances provision. Essentially, if some kind of emergency comes up, or you have to be away on business for another state entity or something like that, this provides a few different ways for appearing remotely. The law, when it was put into effect during COVID, said, which is the part of the paragraph that is listed as removed from the law. This is from section 54953 of the government code. Previously said, you can't do it for more than 3 consecutive months or 20% of the regular meetings of the local agency within a calendar year. They have removed that provision and replaced it with the sort of 1, 2, 3 you see in the second one, which is based on how many times the body meets, there's a set number. So you all meet regularly 3 or more times per month. Option 3, which means you could use these provisions for up to 7 meetings per year. Now, if I can go to the next slide, please. As I noted, this is still, as of right now, set to sunset at the end of this year. And as of January 1st next year, and I don't have any inside information as to whether the legislature is, I think these are good additions. I don't know why they're letting them sunset. It's my hope that the legislature steps up and continues it in some way or another. But there was always an old way to appear remotely. So we call it traditional Brown Act teleconference exception. And this slide is just sort of a reminder of those things. Essentially, you can appear remotely for essentially unlimited amount of meetings under certain circumstances. One, the meeting agenda must be posted at the teleconferencing location consistent with Brown Act requirements, which means 72 hours in advance for a regular meeting. So you have to post the agenda. You have to, identify in all of the agendas where the teleconferencing locations are. You have to make that location open to the public. So if you're on vacation in a rental house somewhere, if someone from the public shows up, you got to let them in and sit in the room with you and watch the meeting with you. Let's see. One issue is that a quorum of the board must be present within the jurisdiction of the district. That's for this to happen. All votes must be by roll call. So those are kind of the ways to appear remotely. As of January 1st, this will go back to being the only way to appear remotely.
That's a question.
Go right ahead, Mr.
So I want to emphasize that last point. So if two members are in Compton and one in Temecula, they don't have to be a majority in the building. They have to be within the boundaries.
The law states within the jurisdiction of the body.
Thank you.
Okay, and I'm so glad you brought that up.
Mhm.
Mr. Palakapalan, go right ahead.
However, that's not the case if you're doing just cause or emergency voting on it. It requires a quorum at the one location. Or this is the remote participation, you could be anywhere. But if you're doing just cause or emergency, you have to have a quorum at a location.
Right, which would,
Where does it say that?
It's in the, yeah,
If this explanation here, of which Mr. Larson just stated, within the jurisdiction, that is the state law per the Brown Act, and that overrides, and I don't know where you read that other part, Mohan, but to me, that overrides it.
and
Doesn't
it's
it?
specifically, this is for the just cause and emergency, and that's actually in a slide that was given to us before, and it's also in the government safety code, in the code also.
yeah, I think it is another state code provision. I don't know it well. I trust you're representing it well. I mean, I think to the extent it does state that, I would not view the two as being in conflict. I think, you would still, if you had three in person, you would still be complying with the Brown Act. So, I would view that as, I would follow that requirement if it's in the health and safety code is my conclusion.
Ms. Thomas, your thoughts? I mean, with respect to, I know we had some discussion in the past about the boundary issue.
Right, and I believe under the traditional Brown Act, it was my understanding that it just had to be within the jurisdiction. But I believe I read somewhere in one of the recent updates that if we are going under I think it was maybe AB 2449, the just cause emergency, that there needs to be a quorum of 3 people at one location, as Mr. Balapalan was stating. So
Yeah, and I think we have in some case violated that provision of the Brown Act, but been rectified recently. So, and that's for just cause and emergency, And is that the only slide, or are you having,
This
this is the only slide you have? for your
there are
presentation?
more.
Oh, more, okay, I'll wait.
But so actually I do, yeah, I mean, I wasn't prepared to go into detail on the just cause and emergency because those provisions you're discussing have not changed since then, but,
Except the just cause is still 2 though, right? And emergency is changed to 7.
no, that 7 it applies to any of the just cause or emergency. And a combination of those as
No,
well.
So folks, why don't we let him get through the presentation? Because there are some amendments that we really need to hear, especially one dealing with ADA.
Yeah, so the next slide is the ADA slide. All right, so the ADA, the Americans with Disabilities Act, essentially says employers need to provide reasonable accommodations for those with qualifying disabilities under the law. And there was a question posed to the Attorney General about whether a government body that is subject to the Brown Act must allow remote participation as a reasonable accommodation for disabilities under the ADA. And the Attorney General writes these opinions that are sort of the Attorney General's analysis. Now, these are not binding on courts, but they're very persuasive on courts. So courts tend to look at these. They usually would follow the AG's analysis. But as I said, it's not binding. This is not a court case. This is not essentially what the AG said is that, yeah, we do think that allowing remote participation is a reasonable accommodation that a body should provide to those with a qualifying disability. The slide has the definition of a qualifying disability there. They do state that the goal is to simulate in-person participation, and they came up with a couple conditions that they think are mandatory to use these remote participation. The two that they came up with are you have to use video conferencing. You can't just call in on a phone. And you have to disclose all adults who are present at the remote location. They did say there may be other conditions that should be followed. We're not going to say every single one, and it may change over time, but the goal is to simulate in person. They also pointed, I'll note, to the recent additions to the Brown Act for remote participation that went into effect during COVID as evidence of showing a legislative intent that under certain circumstances it's okay to appear remotely. I don't know if the AG's analysis would therefore change once these additional provisions that they relied on sunset. My recommendation would be to continue to follow the traditional remote appearance rules for remote locations. That provides another level of safety. There are some risks with relying only on this AG opinion and not following the traditional Brown Act requirements. Questions on that one?
I have a question in the sense of, so would that also be part of how many board members have to be at the AQMD location of Diamond Bar? Or is this in addition to that, and there would not have to be 3 members there?
No, I do think the Brown Act's clear that you need a quorum present in the jurisdiction. This would not override that requirement.
Thank you.
And Mr. Attorney, just to be clear, if in fact we're posting pursuant to the old provision, not any of the overlays, but the old provision of the Brown Act, correct?
Correct.
All right. Alternates, you have any comments?
Yes, I'm hearing that within the jurisdiction. So does that mean nowhere abroad or outside of the jurisdiction? I'm assuming that's what that means.
It means within the physical boundaries of the South Coast Air Quality Management District.
So the person that is remotely still needs to be residing in that
No,
jurisdiction.
it just means a quorum of the board needs to be within that jurisdiction.
Okay.
So an individual, so long as a quorum remains within the jurisdiction, an individual could be outside and participate from outside the jurisdiction.
Okay. Okay. Thank you.
All right.
So the next slide. The last two, I don't think have much of an impact on your business at all. There were some amendments to when a declared state of emergency allows the board to meet virtually. The big changes here are that social distancing restrictions imposed perhaps by the state are no longer a justification alone to hold teleconferences. That was a COVID rule that's no longer in effect. And the law requires that you make renewed findings of imminent risk under a state of emergency. Previously, you had to do that every 30 days, now every 45 days. Again, we hope that this will not come into play. Next slide, please. This one's probably even less of an issue for you all, but the Brown Act does allow a public entity to meet in closed session to discuss with law enforcement certain threats, physical threats. They've added a provision that you can do this for non-physical threats to critical infrastructure, which they have in mind cyber attacks and that sort of thing. So if the board is subject to cyber attacks, it has the ability to meet in closed session with law enforcement to discuss those issues.
All right, Mr. Kerman.
So just in general, though, it's not just law enforcement. I mean, for a cyber attack, we could meet in closed session with our IT person.
Yeah, I believe that's correct.
All right, any other comments of Mr.?
Now, I'm
Arson.
reading the code.
Yeah.
It does still limit the one provision, the just cause, only to two. Two, yeah. On the other one, you have seven, and I think Pearman brought up an issue, and I didn't realize it's seven total, or is it seven for the emergency provision, but two for just cause and, seven, so total of nine you could utilize, or seven total, it's not very clear, but the just cause is two. That hasn't changed.
My
Okay.
understanding it's seven total, and maybe mistakenly, they didn't modify the two for the just cause, and they made a recent change, so it's a bit ambiguous, but
Yeah.
one interpretation is you still only get two just cause,
Yes.
somehow seven.
No, and clearly they stated two just cause only, in the code.
I
So
have,
maybe two just cause and seven total for the
Seven
combined.
total for the, yeah.
Because my recollection is that this, where they do seven total, they refer both to one and two, the two options, just cause and emergency. So
Right.
I would treat the seven as a total for the two.
Total for the two. And so just cause two, five basically for the emergency. Basically,
So you
yeah.
can have zero just cause and seven.
Seven, yeah, right, exactly, yeah.
Correct.
Yeah, right.
Ms. Verdugo Peralta?
yes, okay. Now, the word emergency kind of bothers me because of the fact that, like myself, yes, there was a surgery and obviously I couldn't attend on the day of surgery. But subsequent to that, if an individual is under the care of a doctor that has not released them to come back, and for me, it's a long distance. How is that interpreted? Because it's obviously you're not in an emergency, but you're still part of a medical situation.
So the code does define emergency circumstances, and it said it means a physical or family medical emergency that prevents a member from attending in person. Let's see. So, I mean, it doesn't get defined beyond that. I think you would just use a reasonable interpretation of what's an emergency at that point. And if someone from the public feels you've abused your interpretation of emergency, they would bring a Brown Act letter and let you know that. I think there's some discretion of using a reasonable interpretation of that definition.
Dale, can I ask then, so with the ADA provision that you mentioned,
Mhm.
okay, in that scenario that Ms. Verdugo Peralta brought up, so now we're, let's say, outside of the window of the emergency, but now for all these reasons and limitations, as we saw in the ADA language, then that does not count towards the
Correct. That is
two and
separate.
then the
It's not, that
total
is not
seven.
just cause or emergency.
So I have a feeling there may be, to this point, like various justifications, but from a medicine standpoint, I would see that person as needing reasonable disability accommodations, because of transportation
Correct.
issues or ability or this, that, or the other. So,
Correct.
and then,
And-
and it sounds like that there is no set total amount for the ADA provision, correct?
Correct. No limit. Again, this is not law in the Brown Act. This is the AG's opinion. There's some element of relying on that. However, under that opinion, there's clearly no limit to that. I would recommend that the hearing board make a finding or a determination that it is doing this as a reasonable accommodation to a qualifying disability.
Now, I think Faye and I had looked at it, and the just cause and emergency, it did require a quorum at one location.
For those uses.
For just that, not for the
Right.
regular Brown Act. And it wasn't a slide that, you had presented before. I'm trying to find that section in the government code that says that, but I don't think that has changed.
That has not changed.
Yeah. So there needs to be, that's all, a quorum here, which is three.
Well, actually, it says singular physical
Right.
location, so actually, three of us can meet in Compton.
Yeah, but, yeah.
It does say a singular.
Right. I hope.
I think sometime.
Yeah,
Yeah,
okay.
the only
Yeah.
limitation is in a singular
Single
physical
location,
location,
yeah.
clearly identified
Right.
on the agenda.
And that's relative to just cause.
And,
Right, so we're looking at all these overlays, so we go back to the original, It's boundaries.
Yeah, that's-
And the boundaries of this agency consist of 4 counties. Huge, huge and voluminous. All right, Counselor, any other comments you'd like to tender?
No other comments from me. Thank you, Chair.
All right, members of the hearing board?
Yeah, I know you addressed Mr. Samiano's concern about location. So you're saying if I'm in Arizona, I can participate on vacation there?
I see no reason why you could not.
Could not.
Other
But no
than-
member of the public, can actually, really,
Arizonans might want to hear about the South Coast.
yeah, right. Okay, that, seems sort of making, I'm not saying, mockery of the Brown Act, having participation, allowing them to participate. I can be vacationing Hawaii and,
I mean, you would also need to post that agenda
yeah, I mean,
in
that's
time.
right.
Yeah, and there's one provision we've not discussed. You don't have to post if you're on the business of another governmental agency. So if you're on multiple governmental boards and you're traveling on behalf of that agency, until it sunsets, it's just cause.
That's right.
No
That is
post
one
at
of the
all.
identified just cause reasons.
Yeah, so well, we thank you, Mr. Larson.
Thank you. It's good to be with you.
All right, members, alternate members, any closing comments you'd like to offer?
Just good to see you, Mr. Larson.
All
Good to
right.
see you as well.
Okay, at this time, hearing no further comments, Madam Clerk, we good? From the clerks, we have all the paperwork we need. We've signed every document. All right, okay, good deal. All right, we're hereby adjourned at 11:10 a.m. and off the record.
Have a good weekend, everybody.